Hi, Attorney Steve Vondran here. We are talking today from the broker Don't Do Me Like That files. This is about exclusive representation, and a lot of brokers in California are realtors, and as realtors you have the broker duty of ethics, the code of ethics, and one of those rules, it's Rule 16, talks about not doing something inconsistent with the exclusive representation of another broker. In short, what that means is when a broker has a listing and you know they have a listing, you need to respect and honor that relationship. I know it gets tempting out there in the crowded marketplace, the competitive marketplace where big commissions are on the line, to go in and interfere and try to do something to disrupt the relationship, to try to get the current broker, maybe make him or her look bad, or try to do something to get in there and get that listing. Maybe act like they don't know the market, or they're not working it like they should, those kinds of things. As a broker, you need to respect, just like I do with other attorneys, I have an ethical duty to respect when another client is represented by an attorney and respect that relationship. It's the same thing in this setting as a real estate broker. That comes under the code of ethics. And we're going to talk about that, and when that's interfered, what types of causes of action might you have if you're, let's say, the listing broker, and now you've lost your client or you've lost a commission. So we're going to talk about some of the interference causes of action in California. So in California, there's basically 3 different causes of action that you can look for. Not to say this is an exclusive list of the types of causes of action you may raise if somebody interferes with your exclusive listing, your exclusive arrangement. But these are what we call the interference torts. Okay, so 1, you have a cause of action where someone tortiously induces a breach of contract. What are the elements of that? Generally speaking, the elements you're going to have to show are 1, that you had a valid existing contract, for an example, a listing agreement with the seller. 2, that the defendant or the party that intermingled had knowledge of that contract. 3, that the defendant or the wrongdoer intended to induce a breach of the contract, in other words, trying to interfere with your contract so they could get the breach. And you also have to show 4, that there was an actual breach of the contract. So the valid existing contract, defendant's knowledge of the contract, their intent to breach the contract, and an actual breach. The breach needs to cause your damages, so you need to be able to show how you would have been able to prove your damages existing. So that's one cause of action, intentional inducement of a tortious inducement of a breach of contract. The second interference type of tort that you might name in a complaint against another broker or in an arbitration setting, if there's a duty to arbitrate, you need to look into that, and you may need to seek separate counsel on that issue alone. A second interference claim in the broker Don't Do Me Like That segment is interference with an existing contract. So we talked about the first one, which was an inducement, inducing a breach of the contract. This one's not so much inducing a breach as it is interfering with an existing contract. So if you can't quite prove that there was an inducement and a breach, but if you can prove this tortious interference with the contract, you may be able to have a cause of action for interference with an existing contract. Now, under this tort, you need to also show that the conduct was independently unlawful. Now, this can get a little tricky, but one of the things where is if you can show a violation of the Realtor Code of Ethics or trade association rules or some sort of other rules, regulations, or guidelines, if you can show that the conduct that they engaged in was wrongful under some other standard, aside from just the interference, then that can satisfy the requirements. These are very fact-specific inquiries that you may want a real estate firm like myself to look into, but that would be the second interference type of cause of action you may be able to bring. And finally, the third cause of action in the broker Don't Do Me Like That segment is interfering with an existing prospective business relationship. Okay, so we talked about the first one, which was intentionally inducing a breach of a contract, where you have a breach of contract. The second one in interfering with the contract. And this third one is even where you don't have a contract, if you have an existing business relationship, an economic relationship between a broker and a seller with the probability of future economic benefit, once again, with the probability of future economic advantage, and defendant has knowledge of the relationship and intends and engages in acts that are intended to disrupt the relationship, you can also have a violation of this tort. This is another cause of action that you can allege in a complaint or in an arbitration setting. Now, here you need to show that the defendant knew its interference was certain or substantially certain to occur. As we talked about in the second cause of action, you also need to show that it's independently wrongful. For example, violating the Realtor Code of Ethics, and there's a case on that we'll brief for you, the Stevensons versus Grubb Ellis case. But that's a case that illustrates this principle of having an independently wrongful act, such as violating the Realtor Code of Ethics. You need to show your damages. You need to show that you probably would have recovered a commission. That can be tricky too. So those are things that you want to be thinking about when you have another party interfere. Sometimes people think, oh, it's free competition, I can do whatever I want, I was just in and out, and oh, it was real subtle what I was doing. It's very fact-specific inquiry. If you're concerned that you've lost a commission over the acts of some other intermingling agent, give us a call, 877-276-5084, or find us on the web at attorneysteve.net. That's attorneysteve.net. I myself am a California real estate broker, so I know the issues that you face, in addition to being a licensed lawyer in California. So if you're not sure, if you think you have a case, give us a call. We can send a demand letter. We can represent you in arbitration proceedings, or, if warranted, under the facts, filing a civil lawsuit on your behalf. This is Attorney Steve out, and be good out there in the marketplace. Don't go trampling on other people's exclusive listings. Thank you, and we look forward to working with you.